Hello friends, in this video I am going to discuss Industrial Dispute Act 1947. The Industrial Disputes Act 1947 came into existence in April 1947. It was enacted to make provisions for investigation and settlement of industrial disputes and for providing certain safeguards to the workers. This act contains 40 sections divided into 4 chapters. So let's have a brief discussion on this act. The first of all, what is industrial dispute? As defined in Section 2K of Industrial Dispute Act 1947, an industrial dispute is any dispute or difference between employees and employers, or between employers and workmen, or between workmen and which is connected with the employment or non-employment or the terms of employment or with the conditions of labor or any person. So it's mean as a conflict or difference arises in terms of opinion between management and workers on the terms of employment, it is known as industrial dispute. It may be a disagreement between an employer and employee's representative, usually a trade union, over payment and other working conditions, and can result in industrial actions. When an industrial dispute occurs, both the parties, that is, the management and the workmen, try to pressurize each other. The management may resort to lockouts, while the workers may resort to strikes, picketing, or gheraos, etc. Now, the next question is, what are objectives of this act? Following are the significant objectives of this act: to secure industrial peace and harmony, to provide machinery and procedure for the investigation and settlement of industrial disputes, to provide negotiation facilities. Next, applicability of this act. The act covers the whole of India and applies to every industrial establishment carrying on any business, trade, manufacture, or distribution of goods and services, irrespective of the number of workmen employed therein. Secondly, every person employed in an establishment for hire or reward, including contract labor, apprentices, and part-time employees to do any manual, clerical, skilled, unskilled, technical, operational, or supervisory work is covered under this act. Note, this act, though doesn't cover to person mainly involved in managerial or administrative work. In other words, person engaged in a supervisory capacity and drawing more than 1600 per month, or executing managerial functions, and persons subject to Army Act for Air Force and Navy Act, or those in police service, or officer or employee of a person of a prison, or not covered. Next, settlement of dispute. The Industrial Disputes Act 1947 provides 3-tier machinery for the adjudication of industrial disputes. Those are labor court, industrial tribunal, and national tribunal. The labor court remains at district level, industrial tribunal, that is state level, and national tribunal is national level, that is the highest authority to solve such disputes. Next, that is methods of industrial dispute settlement. Following 3 are the important methods of dispute settlement: conciliation, arbitration, and adjudication. Conciliation, in a simple language, means reconciliation of differences between persons. Conciliation refers to the process by which representatives of workers and employers are brought together before a third party with a view to persuading them to arrive at an agreement by mutual discussion between them. The alternative name which is used for conciliation is mediation. The third party may be one individual or a group of people. Arbitration. It is a process in which the conflicting parties agree to refer their dispute to a neutral third party known as arbitrator. Arbitration differs from conciliation in the sense that in arbitration, the arbitrator gives his judgment on a dispute, while in conciliation, the conciliator disputing parties to reach at a decision. And last one, that is adjudication. It is the ultimate legal remedy for the settlement of an unresolved dispute. It's a reference to adjudication by the government. The government can refer the dispute to adjudication with or without the consent of the disputing parties. When the dispute is referred to adjudication with the consent of the disputing parties, it is called voluntary adjudication. When the government herself refers to dispute to adjudication without consulting the concerned parties, it is known as compulsory adjudication. This is all about Industrial Dispute Act.